Welcome to the Florida Family LawCast on new rules and forms with Cory Brandfon. My name is Amber Kornreich, coming to you from Miami, Florida. Today's featured guest is Cory Brandfon. Cory is a partner at Harris, Hunt and Dare in Tampa, Florida. He's a graduate of the University of Miami School of Law and Washington University in St. Louis. He is a leader at the bar, having served in various roles, including as chair of the Family Law Rules Committee, in which role he argued for revisions to the summary judgment rule at the Florida Supreme Court, and he also serves on the Family Law Section's Legislative Committee. He is known notably as the originator of the new financial affidavit and joint verified waiver, seeing these changes through from referral to adoption. He's also active locally in the Hillsborough Bar Association, including as an executive council member for the Marital and Family Law section, and also serves as a leader in the Stan Givens Family Law Inn of Court. In all of these roles, he is known for his command of the law and rules, ability to manage complex issues, and as an extremely hard worker and mentor to younger attorneys. He's passionate about the rules and educating others about the process. We're fortunate to have him here today. Thank you, Cory.
Thank you so much, Amber. I'm happy to be here.
Cory, what's the process for a rule change?
Thank you for asking. So I'm glad to be able to speak about this because I think it's an under-discussed aspect of our profession. So anybody can make a referral to the Florida Bar Family Law Rules Committee to ask them to consider a rule change or a revision to a form under their umbrella. And so it really is as simple as reaching out to either the bar liaison attorney for that rule committee or to a chair or a vice chair or even just a member of the committee and asking that it be added to the agenda for the committee meeting and considered. So you start there, and then if the committee decides that it's something that they want to act on, they will convene a subcommittee to investigate the issue and formulate a recommendation. It'll then go to the full committee for a vote. After that, there are opportunities for the public to have an opinion because proposed rule changes get sent to the Florida Bar publications publicly throughout the state for a comment period. And of course, the family law section also has the ability to comment on the proposed changes before the Supreme Court ultimately considers it. And so if it comes back to the committee based on comments, the committee will decide whether they want to make further edits. If the comments are substantial, they'll typically send it back to the subcommittee for further work before it may come back before the entire committee for a vote on to what extent they may want to make some changes to the prior proposal. But at that point, it's going to go to the Supreme Court, and the Supreme Court is going to decide whether it wants to have oral argument or not. Oral argument can be requested or not. It's uncommon, but I did it once. It happens occasionally. And so that Supreme Court period is an opportunity for even further comment. So usually the Supreme Court case will be opened at the Supreme Court, a rule case, and there will be another window for comments. And so at that point, after the comment period is closed, then you have the waiting. And so sometimes the Supreme Court is very quick and you will get a rule opinion. Other times when they have very busy dockets, you can wait several months. But ultimately you get the Supreme Court's decision on what may have been something that you referred to the rule committee.
Moving into changes, what has changed about the Florida Family Law Financial Affidavit?
So thank you for asking. So this is something that I was privileged to work on with the committee for about 6 years, from 2018 to 2024. And I grouped the changes into three big buckets. One, to modernize the form. Okay, so you'll see things like streaming services and other references to cryptocurrency and things that either didn't exist or weren't prevalent at the time of the prior versions of the form. Secondly, it's to increase consistency. Okay, and so certain things like there were redundant references to monthly, and there was some terminology that didn't jive with how it was used. So for example, I'll use on line 40, under monthly expenses for minor dependent children, you now have the term childcare, and you now have reference specifically to extracurricular activities. And so we tried to make it consistent. And so another example then is, with health insurance. And so one thing that I often experience in my practice is people would have a hard time figuring out where to put the health insurance information within the form. And so we tried to revise the instructions to be as clear as possible about how to break up the different health insurance components. And then another change along those lines, again, sort of for consistency's sake, is under the monthly payments to creditors section. And so we added in the clarification that you should not include things under there that are listed elsewhere on the affidavit. Because, for example, if you're including your credit card that you use to go grocery shopping, and then you're also including the grocery expense up above, then you're effectively double counting those expenses within the affidavit. So that's something else that we saw commonly in our practice and that we wanted to revise in this form. So those are just a couple examples of what I would call sort of consistency, or things that we were seeing were often not being done properly. And then the third bucket, I would say, is trying to make this more useful for different people and for different stages of the case. And so as part of passing this, the Rules Committee also passed, and the Supreme Court adopted, a joint verified waiver of filing financial affidavits. I say that because as we were working on this, myself and others were cognizant of not wanting to require more information, or sensitive to doing so at least. And so when we were able to get the joint verified waiver passed, we had confidence that at least people who have been able to reach an agreement and have decided not to file their financial affidavit would be able to do that and would be able to keep this between themselves. And so in that sense, this document then can just become a helpful tool for settlement, for example. And so I'll point out just a couple examples of that. And so right at the beginning, we asked people to indicate, if they're unemployed, their highest gross earned income in the past 5 years. And so just a data point that might be helpful when you're contemplating possible imputation, okay? Other examples of that, and this is minor, but bolding where it says attach sheets itemizing expenses. This might shock you, but some people don't do that. And so we bolded it so that way it would be clear to people that they are to do that. We also, under households and vehicles and children, all three, indicated how many households do you have? How many vehicles do you have? How many children do you have? Because when you look at an expense section, it's going to indicate one thing to you if it's for one house or one car or one child versus 3 of each, right? And so we thought having that information and having that information broken down, at least for houses, by the house would be very helpful. Again, it's going to give you, I think, a more complete view into need and ability to pay earlier on. And then, so a couple things then that I know are somewhat controversial, but we included things like gambling and lottery, tobacco, alcohol, and vaping, attorney's fees and court costs. So those are examples. Personally, when I look at this financial affidavit and I see those things, one, I may see need, I may see ability to pay. When I see people engaging in some of these things and some other discretionary activities, right? It may speak to need, it may speak to ability to pay. But on the attorney's fees point, that's something that for many people may be their largest, second largest, third largest expense while the case is going on. And so I think to have this form and to not have that information is incomplete. And so breaking that down, it may be more helpful at a second financial affidavit or a third if a case drags along, right? You might not have a complete sense of that at day 45, but again, trying to provide more information that may be helpful for settlement purposes. And then finally on that point, really breaking out fair market value between marital assets, non-marital assets, marital liabilities, and marital liabilities. Something that I saw happen often was, pardon the pun, but people would get married to a number, right? They would see some big number and it wouldn't really be broken down between marital and non-marital, where you're just checking the boxes. But now you're totaling the columns between marital and non-marital. So early on, you have a better complete picture of what the person contends is the marital estate versus the non-marital estate. So that's not an exhaustive list, but again, I sort of put it into those three buckets: modernize, create consistency between the form, the rules and statutes that we use, and then three, trying to make this more helpful, not only to the court, but for folks trying to reach settlement.
Well, that is such a helpful explanation and some really meaningful changes. Shifting to the topic of limited representation, what is the limited representation packet and what should lawyers know about it?
So as part of the June 2026, 2025 amendments to the rules, the Supreme Court has promulgated forms relating to a limited appearance. So you can have limited appearances for different purposes. One more popular one that I've seen lately is a limited appearance through mediation, for example. You can have a limited appearance for a specific hearing, say a fee hearing. Maybe you're coming on the case trying to get fees, so maybe it's for that specific purpose. But as opposed to a full representation, it is inherently limited in scope. And so the Supreme Court has promulgated several forms to indicate to the client the nature of that relationship to avoid any misunderstanding, and also to indicate to the court and to the other side the scope of that engagement. So the court and the other side know, well, who do I send this thing to? Right? What things are going to the lawyers? What things might be going directly to a self-represented party? Or, you could have a co-counsel relationship where one counsel is on a limited representation, right? So the packet of materials include a notice and consent to limited appearance by attorney, a agreement limiting representation, and a termination of limited appearance. And so if you look in the June 2026 packet, you are going to see these forms. Some of these get filed with the court, and others of them are supplements to, for example, a typical engagement agreement or retainer agreement. And so it sets out the parameters of your limited representation.
Cory, it's really inspiring to hear you speak about something you're so passionate about. And so, what can you share a little bit about what has motivated you to do bar service and what advice you have for others who may want to be leaders themselves?
So early on in my career, I was looking for a way to make a meaningful impact on our profession. I felt that to some degree in the day-to-day work that we do when you get to a final judgment. There's that sense of pride and relief knowing that you've helped this person put this thing behind them. But I also found that oftentimes it felt harder. It felt harder than it should, and how hard you would have to work to get that satisfaction of helping that person. I was looking for something more, and so I was looking for, well, how could I help on a sort of a larger scale? And so I had a mentor early in my career, Dennis Kanan. He had been on the board of governors for a long time, and I had seen him and others put so much of their career into bar service, and I was motivated by it. And I saw the camaraderie that they had. I saw that the impact that they had in terms of rule changes and things of that nature. And I realized that this was a unique opportunity to help influence the rules and ultimately legislation that is so important to not only our clients, but to us. If we have frustrations with these things or ideas that these things can be improved, it doesn't happen automatically, right? It takes a concerted effort by many people to make this happen. And obviously, the family law section is so instrumental in that. And so many people put in hard work and I think have the same view that I do. But I recognized that earlier in my career, and I was fortunate to be able to be involved with the Florida Bar Family Law section and the Florida Bar Family Law Rules Committee, and to spend 6 years and to rise to the level of chair over there, working with some amazing people. And it met my desire to influence the process on a larger scale. And so if you're somebody who, has that intellectual curiosity and that desire to, help improve these things, I think you should apply.
Well, thank you so much, Cory, for sharing so much of yourself and your bar service. Is there anything else you'd like to share?
So it's sort of to recap some of the things I've touched on briefly, but the referral process for rules is underutilized. I can't tell you how many times during my 6 years on the committee, I would have people come to me and talk to me about issues in the rules. And of course, I would always run with it, but I would also always take those opportunities to tell them, look, you do now and always will have the ability to make these referrals. And so the success of the rules, of the process, depends on people speaking up when they realize that there are problems and inefficiencies. And so whether your capacity is to shoot that email and make that referral and to stay involved and help people or not, or whether it's to volunteer your time and get involved yourself, I would highly encourage you all to do that. I have found it to be very personally and professionally rewarding. I've met some incredible people over the time that I've been involved, and had the good fortune to work on some pretty neat things. And so I would highly encourage you to do that as well.
Well, thank you so much, Cory. This has been a very motivational and educational session. We really appreciate your time.
Thank you so much, Amber.